Hello, ladies and gentlemen, and welcome to this special edition of Focus on Liberia. My name is Dennis Jai, and we are broadcasting from Atlanta, Georgia. In this special edition of Focus on Liberia, we are here, first of all, to discuss breaking news that happened today. And with me to discuss this breaking news, I have the head of politics here at Focus on Liberia. I call him the political bulldog, Mr. Ansony Sieh. Ansony, welcome to the show.
Thank you, Dennis. It's good to be here. Let's do this.
Right. Before I even introduce our guest, let me just break the news. Today we woke up. Yesterday we went to bed discussing the report from the Sherry Blair Commission. Today we woke up hearing that the Supreme Court struck down the controversial Section 8.5, Paragraph 2 of the CPP framework document. And that section reads, that section of the framework document reads, a constituent party desiring to withdraw from the CPP shall first exhaust the dispute resolution mechanism stipulated in this framework document. If the constituent party which has satisfied the dispute resolution mechanism is not satisfied with the outcome, it shall file a resolution to withdraw from the CPP, signed and duly executed by 2/3 of its National Executive Committee. It being understood, however, that a party withdrawing from the alliance prior to the next presidential, legislative, and local election shall not field candidates in its name. That's from the CPP framework document. We want to welcome our viewers from across the globe. So based on that, that case went to the NEC. The NEC agreed that, hey, you cannot field candidate. It went to the NEC Board of Commission and onwards to the Supreme Court of the Republic of Liberia. That was struck down today. Besides that, it had also the bearings on the ongoing court case involving the ANC political leader, Mr. Alexander Benedict Cummings. Now, the Solicitor General has decided not to move forward with that case. It is so complicated, we can't understand, we don't know why. So we have invited our legal expert on the FOL Justice Forum, Councillor Frederick A.B. Jayweh. Councillor Jayweh, welcome to Focus on Liberia.
Thank you, Dennis. I'm always happy to be here.
We also invited another legal mind who is currently the CEO of 2A Radio and Television, Attorney James and Jensen, who is joining us from Philadelphia. Mr. Jensen, welcome to Focus on Liberia.
Yeah, thank you guys for inviting me, and I'm glad to be on the show tonight with the counselor, and I hope that we will discuss what the Supreme Court ruling has said and all of the fights surrounding that case. And I'm here to also say that the Supreme Court decision is not a decision that cannot be discussed. So we're going to discuss it as we know best regarding that decision and the personalities on the bench. So thank you so much. I'm glad to be here.
Thank you. And we always want to do this. When you invite people to speak on a particular subject matter, you want to give chance for them to talk about themselves a little bit. We know them. We want you to, starting with you, Anthony Jensen, tell us a little bit about your background that make you qualified to speak in this matter. Let the people know. I know, but perhaps my audience don't know.
Thank you so much. I'm James Jensen. I'm the former strategic planning and policy advisor to the then Auditor General John Molu during his tenure as Auditor General of that country. I also serve as the President Public Affairs Director at the National Legislature for a long period of time. My CV is up there. I also serve as the Administrative Manager for the Internal Audit Secretariat. And I graduated from the Louis Arthur Graham School of Law with a Bachelor of Arts degree. I went to Pennsylvania State University. I got a Master's in Law. And for my undergraduate, I got a Bachelor degree in Mass Communication and Political Science. For all of these, I'm interested in people-centered activities And that's where my interest lies, not so much of these big names or the big degrees. So I'm glad to be here. And the issue about has to do with the Constitution, laws, and the rules. And I think those are areas of focus tonight. So I'm glad to be here.
Thank you so much. Let me invite.
And just before you end, when it comes to two-way radio, I'm the chief chief manager for that place. Although we have someone who is patient Blair who is really managing, but these are all creation, and we all want to play our role in ensuring the workings of democracy. So I'm glad to be here, and I'm also glad to speak about my team. I have a good working team who are looking at issues in Liberia. We want Liberia to get better, so that our children and grandchildren after 50 years, they will meet a society that is good and pleasant for their survival.
Thank you so much. We are glad to have you, especially the news just broke today. We reached out to you and you were able to come. Let me also welcome Councillor Jayweh. Just a little bit about yourself, Councillor.
My name is Councillor Frederick Jayweh. I'm a 1990 graduate of the Louis Harder Grant School of Law. Prior to that, I have a Bachelor of Art degree in theology. And I have a Master of Law from the University of Denver here in Colorado. I own and operate a law firm in Monrovia called Africa Center for Law and Human Rights. I'm in and out of Liberia very frequently. I'm visiting there. I also run a federally funded refugee agency in Colorado called Center for Immigrants. And I practice law for about 30 years now. I'm a trial lawyer. I like to engage in legal issues. And I'm happy to be able to explain for our people in Liberia to understand what is going on and how has the Supreme Court current opinion, what is the impact and effect on them?
Thank you. Before we go on, Mr. Ansony Sieh look at these things every day, and so he has a deeper understanding of what's going on with all these cases. So, Mr. Sieh, I want to invite you to lay it all out before we invite our experts here to weigh in on what all this means.
Dennis, thank you, and I want to say a very big thank you for the two legal minds who accepted to come on a very quick notice. And I also want to welcome our listening audience who always make it their duty to join us so that we can talk about a country like Liberia. Yeah, Dennis, this thing is simple. It was called the CPP. I don't know if it still exists. 4 political parties came together, goals, let's field one candidate for president. That was their decision. Well, we can't just do it. They said we have to put a framework together. They put that framework together. The fair candidates, they won. They got certificated by the National Election Commission. But then the sticky issue of who becomes the CPP candidate was that which they couldn't agree on. And then there was this allegation that came specifically from Benin Ayure that Alexander Benedict Cummings, one of the leaders in the CPP, had altered the framework document. So that matter went to court. And that matter has been in court now. And Mr. Cummings has been going to the court for some time, a little over 3 months, now probably almost 4 months. Well, then the CPP got divided on the basis of that because the Liberty Party, that having to be a constituent member or maybe then constituent member of the CPP, a faction headed by Yomli Kaka Lawrence supporting Joseph Boaka, and Musa Belete is another leader in the opposition Liberty supporting Benedict Cummings. So what happened at the end of the day was, because Cummings was sued by the Boaka wing of the CPP, if I can pull it like that politically, then the Cummings wing of the CPP said, well, we're going to find a way to fight back because the Boaka wing of Unity Party and the ALP at some point decided that they were leaving because they couldn't get their way yet, meaning it was not possible for Joseph Boaka to become the candidate of the CPP either through a consensus or through a primary. So when they left, the commissar said, well, you can't do this like this, so we're going to, strike back. So they filed a lawsuit, first at the National Election Commission, stopping Joseph Imambuaka, Unity Party, and Benin Ure ALP to not feed candidates in any other election, including the presidential election. So that matter subsequently went to the Supreme Court, and today, just when we didn't expect, the Supreme Court has given a ruling on the essay clause of the CPP that the Cummings win of the CPP was using to prevent, legally, according to them, Joseph Imambuaka and ALP from feeding candidates. So this is where we are today, and the interesting thing here is that the Seba Serena Sifa, who is the Solicitor General of Liberia, because of this ruling from the Supreme Court concerning the essay clause, he is saying that also has some kind of bearing on the case against Mr. Cummings. So he said Mr. Cummings is a free man, and this is very, very, very astonishing, and that is why we thought to bring in the legal minds, and I have 99 questions. I hope we can get to them today. You are muted, Dennis.
To start, let's read the ruling from the Supreme Court. It reads, wherefore, and this is portion of it, the last paragraph pertaining to the exit clause. Wherefore, and in view of the foregoing, the ruling of the hearing officer, which was confirmed by the Board of Commissioners of the NEC, is hereby reversed. The purported Section 85(2) of the CPP framework document, being manifestly against the Constitution, statutory laws, and the public policy, is hereby declared null and void ab initio. The appellants ALP and UP, having duly withdrawn from the CPP, are free and at liberty to pursue any political interest in their names, including the fielding of candidates in the ensuing Lofa County senatorial by-election, if they wish to do so. The clerk of this court is ordered to send a mandate to the NEC informing that body of the decision of this court. It is hereby so ordered. Given under our hands and seal of the Supreme Court of Liberia this 3rd day of June, AD 2022. Let me start with you, Anthony. Jensen, what do you make of this?
Thank you so much for reading that closing paragraph of the ruling. I would have loved to read the full ruling and also to understand who are those justices, or if any of the justices had a dissenting opinion. But relative to just what you have read, I think the Supreme Court ruling has...
Attorney Jensen, sorry, excuse me. Let me read. So this is signed by Chief Justice, Supreme Court of Liberia, that's Francis S. Bokwa Sr., James Arthur H. Wolokoli, Associate Justice, Supreme Court, Sieh A. Yene G. Yuo, Associate Justice, Supreme Court, Yusuf D. Kaba, Associate Justice of the Supreme Court. The piece of document had those names.
Okay, so it means is there one person didn't sign?
Yeah, so it's possible that the signature be on other pages. But
no, Mr. Justin Nangwe is ill and out of the country.
Oh, okay. Okay. That being said, let's discuss with the meat of the paragraph. That decision has added confusion into what is going on in Liberia. And it suggests to me that the Supreme Court herself has missed a mark. Article 17 that is being relied on by the Supreme Court emphasizes the right of political parties or individuals to associate and disassociate. For any political party to associate is not an end in itself. This Constitution of Liberia, speaking about association, the National Legislature has enacted a law as to how people associate or how political parties associate. And to disassociate, there are procedural steps. And I fully agree with the National Election Commission And I disagree with the Supreme Court. Because if political parties came together to associate, they brought together their assets, their capital, their resources. If the Supreme Court would just sit from upstairs and say, hey, the people said they have withdrawn and so it's considered withdrawn, what happens to the asset of those people? Let's assume they have computers. How do they discuss those matters? It's only in a court of law, a competent court of law that will fully accept a petition to withdraw. And how you deal with those matters would have been handled at the National Election Commission. The National Election Commission is the constitutional charge that is charged with the responsibility to conduct the affairs of political parties in Liberia. So the National Election Commission said, wait a minute, we have certificated you people to operate in the land Liberia, and to do that, you have given us a reliance. All requirements that we wanted, you have submitted to us, the framework document. And they said, hey, as far as we are concerned, you are still a CPP until a petition is filed before us, wishing to withdraw. And that's what I stand. And I said, even where those political parties, ALP and UP, went to the magisterial court, this, in my opinion, at the first instance, was an administrative issue. Those political parties disagree with their own framework document on the ground that it was altered, needed to take all of the pieces of evidence to the National Election Commission to challenge what is in the possession of the National Election Commission, to which the National Election Commission has certificated them. But they didn't do that. So as far as we consider, the National Election Commission says, wait a minute, we don't have future fry in your conflict. But all we are saying is that if you feel like, hey, you are injured and the document before us is not legitimate, do what you need to do for yourself. File a petition. We will listen to you. That was the most prudent and legal thing to do. Now, for the Supreme Court to have either remanded that decision, they said, well, they are reversing. To say what? So what happened to all of the outstanding issues? The people said that were withdrawn from the operation. Mm-hmm. So what happened to all of the issues? I didn't know their assets. I didn't know what they had in common. How are they going to distribute them? If the Supreme Court just stay from upstairs and say, okay, this is done with. How? The Supreme Court should know better. Okay, let's go on the other side, on the other side of the case. There is a pending case. The Supreme Court is in knowledge of a case that is ongoing at the magisterial court. That case has overstayed. In fact, that's an issue that President Kopo should have handled ever since. The magisterial court should not have had that case in that place for more than 30 days. That's a rule of Rule 9 of Rule 9 state that. So for that case to have been in there and people playing politics around it, that was an issue in itself. But be as it may, that case is still at the court. Now the Supreme Court has making a decision that the judge in the magisterial court hand is tied. Even let us, for instance, how you call it, the SG is talking about, he will drop case and other things. Those are not the way to drop case. So his press statement is not sufficient. He will have to file a petition to withdraw whatever he thinks he's going to withdraw. But let's see how that play in.
Right. And we'll come to that. We'll come to the SG. Go ahead and your thoughts, sir.
So in my view, the Supreme Court has not resolved the matter, and it is not the Supreme Court business to call for evidence, pieces of evidence. So the body responsible, the body constitutionally set to deal with this matter, they took that decision. We agree. The Constitution says the Supreme Court is the final arbiter, but the Constitution did not tell us that we cannot discuss the matters. In fact, as a lawyer, that's my responsibility. All common laws, I'm supposed to. In fact, that's why I went to law school. That's what primarily I studied. All right, constitutional law look deeply into opinions and see whether they themselves are making error. And in my view, this ruling, it causes more confusion than the talk of public policy. For God in heaven's sake, it's a confusion. It's not curing anything in there. The political parties, where are they?
Thank you.
The alliance, the collaboration. We asked the Supreme Court a lot of questions. They wouldn't answer at this time, but it is us that are now lawyers. We should be discussing this matter. And before I close on this matter, I think it is now about time that Liberians should be conducting a serious survey as to how Liberians perceive the Supreme Court. No man should be an ally in a democratic society. Every man, when you make a mistake or when you make a decision, it should be scrutinized, it should be observed, so that the next decision you will think twice that, look, anything we say, we have enlightened people in the land. And they will look at it in a careful note. And that's what I'm here to look at this opinion very seriously tonight. Thank you so much.
Thank you, Attorney James Jensen. Ladies and gentlemen, if you are just joining us, this is Focus on Liberia, and we are discussing the Supreme Court ruling today and its impact on the ongoing forgery and criminal conspiracy case of Mr. Alexander Benedict Cummings. Councillor Jayweh, what's your take on this ruling today?
What's your opening case? Your opening argument is it?
I would, disagree with everything that Attorney Jensen has said. And as a junior brother, I will advise you to look at cases from the factual point and ensure that politics doesn't sway you. The case before the Supreme Court that was decided today is pretty legal. I have told this show and told the Liberian people before that Section 8.52, written by, I think, about 5 or 7 lawyers, I think it was led by Councillor Benedict Sanon. I said that section of the framework document will not stand a constitutional test, and that the matter that Mr. Violate and Mr. Cummings took before the Supreme Court, before the National Election Commission. National Election Commission had no jurisdiction to begin with. What do I mean? National honored our legal structure. Administrative agency of government do not have the right, has no authority to declare the rights of parties. So where the Unity Party withdrew, where the ALP withdrew, the only institution in the country that could declare rights would be the court, not administrative agency. And so the National Election Commission wasted a whole lot of time, wasted government money to conduct a hearing in a matter that it had no jurisdiction because it could not declare the rights of either the ANC group or could it declare the rights of Ambassador Boakai and Nyombi Kanga, Senator Nyombi Kanga, and the rest of them who are on the other side. Howbeit the matter traveled to the Supreme Court. And I said before that lawyers who write a law that intend to hold parties together, when that law or when such provision runs contrary to the Constitution, the Supreme Court will strike it down. And that's what the Supreme Court has done today with 8.52. The law of contracts, in order to even call, and I heard the ANC people and other lawyers, my colleague and other well-respected lawyers said that Article 25 of the Constitution, which protects the right to enter and execute a contract, was the shield that protected them. And therefore, they were now violating Chapter 3, Article 17 of the Constitution, like the right to associate and not to associate. They even went further from the 8.52 to state that, look, if ALP withdrew, if UP withdrew, or any other of the the 4 political parties that came together and contracted, presumably contracted, to form a union, you cannot field candidate in your individual party names until after 2023 election, 6 months thereafter. Now, who writes that kind of law? When you write like that, you need to match your writing against what the Constitution will say. And because the right to vote and be voted for is a constitutional right, that right cannot be taken away by any 2 person or 4 people sitting in one room and say, if this happened, you cannot run, you cannot field candidate, you cannot hold a political party. So the Supreme Court said, look, in as much as Article 25 supports the right to contract, party right to contract, Article 25 is not applicable in this case because they presume or purported contract that they said they entered was not a contract at all. Now, what is a contract? A contract is an agreement between parties or 2 people or 4 people that must not be unduly influenced by anything. There will be a consideration, there will be an offer, there will be a consideration. And once the contract appears to have undue influence, it is considered an adhesive contract, meaning a contract that forces your hand to become a part of a union. In the CPP situation, the ANC people, some other lawyers were going around, Violate himself were going around arguing, oh, we got them. The law we signed, 8.52, say when you leave, you cannot fear any candidate. So they are here with us. The Supreme Court said, look, that your so-called contract doesn't exist. Return to your base. Liberty Party can function independently. Unity Party can function independently. ANC can function independently. Because in the first place, Election Commission had no authority to try to listen to a case where the authority to determine who is right and who is wrong, they declare the rights of the party, can only be done constitutionally by the Supreme Court. So where are they coming from?
Thank you.
Councillor Jayweh, let me come in here. Dennis, if you don't mind.
Sure.
2 things I pick up from you, Councillor Jayweh. Right and contract.
Yes.
You said, in the true sense of contract, constitutionally speaking, that does not meet a contract.
No.
So let's start with the contract issue. You define contract and you say when there is undue influence.
Undue influence.
Yeah, then it is not a contract.
I just wanted
let me ask the question. What law is your reliance concerning this undue influence to nullify a contract as not being a contract legally or constitutionally?
So there are elements to a contract. A contract, the parties entering the contract, there will be an offer. There is a consideration. There is an acceptance. When the offer bears a resemblance of an influence under the law of contract, of an influence that appears to impact public policy. Because the right to contract does not include the right to sell your right. Any contract that does that will be stricken down because the law of contract will say, look, was there an influence? For example, Article 8.52 was created with an intention to bind the parties together perpetually. So under the law of contract, when that kind of influence is considered undue influence. The second thing under the law of contract is that there cannot be duress. You cannot compare people to remain in contract. That's why the law allows that. When a contract is broken, there can be other action or damages for breach of contract.
But Councillor Jayweh, none of these parties is complaining of the two things you just mentioned.
Oh no! What you call it? ALP that took the case to that raised the issue. ALP said, wait a minute.
ALP did not complain about undue influence and duress.
Oh yeah. ANC. I mean, not
ALP.
ALP said, look, the contract we thought we signed, and we signed, had nothing to do with an exit clause that says you can leave if you should withdraw. Where did that come from? And was it an act of duress? Was it an act of unnecessary surprise? So then ANC said, look, we are withdrawing. We are withdrawing. ALP said we are withdrawing. And they withdrew. Because ALP that raised the issue said that what we signed did not include section 8.52. And in order for the contract to be a contract, it must not present an unnecessary surprise.
And was that established anywhere that it was actually not what they signed?
All the ANC said that, look, not Coruscant, keep calling it ANC, ALP. Mm-hmm. What ALP said was that, look, what we from the copy of the contract that Nyobi Kanga was able to get from the Election Commission runs contrary to what we signed. In fact, the emblems of the party, the identities, were all in color. But in addition to that, ALP said, look, who put in 8.52? We didn't put it in.
Councillor Jayweh, I get your point there. Let me come to the issue of right, then I will bring Dennis in. On the issue of contract, you are a lawyer, you know about the law. I'm just using my common sense. I believe, before I ask my next question on the issue of right, I must say, I believe there was a contract. It was notarized. The parties signed. The parties celebrated it. It was a contract. That is my opinion there. Now let's come to the issue of right. The Constitution is the one that spells out the rights of individual.
Yes.
An individual can make a decision to forgo a particular right for another. That became the case, in my opinion, with the CPP framework document. I'm referring you to Article 17, because Article 17 is saying to associate or not to. It didn't say to associate in. So when they made a decision to have associated with the CPP, they were in essence saying we will live by the consequences thereof.
So true.
And they fixed their signature to it. That's where Article 25 comes in and says, this is a contract. And you are saying their rights being violated here?
Let me tell you something. Let me answer you. You may decide as an ordinary person to say we will contract out some of our rights. But the law will not accept that.
Okay.
Because those rights are protected by law, and the courts are supposed to uphold them. Let's take, for example, the Unity Party, the ALP, the ANC, and the LP all decided that they were going in one room, they were going to form a unit. And let's assume, as you said, that if the document was signed, it was notarized, it was also filed with Election Commission. That's why the Supreme Court referred to it as a purported. As a purported. Something that you may think that it is true, but it's not true. You may think that you were acting. My problem is the lawyers who assisted to write the framework document, who sat down and saw 8.52 and did not measure it against the Constitution of Liberia. Those lawyers are guilty of ineffective assistance of counsel. I continue to say that.
Can I remind the learned counselor on few fights and issues on law?
Sure.
Councillor Jayweh, let me say this to you, and I think you know this, that the formation of a collaboration or association at the level of the National Election Commission is clearly spelled out in Article 79 of the Liberian Constitution. The National Election Commission has the sole authority to set requirements as to how people collaborate. It was on that basis that those parties, they submitted to the National Election Commission a framework document. That document was the basis at which they were certificated. It was the basis at which they participated into the election. It's the basis at which they brought their assets together. I'm not sure, and I maintain the Supreme Court is in error, in my opinion, and it has set in a lot of confusion. I'm not sure of the assets that the guys may have brought together, but let's assume that they brought together $1 million. How do you dispose of that? How do people withdraw from an association? You are a learned counselor. How do parties that came together, that signed a framework document to collaborate, how do they disassociate? Can you just get up in the morning and say, no, I'm not part of this, and you just walk away? Is that the manner to go about it? Or you file a petition, and that petition is heard, and ruling is given, and a party that that is not certified runs to court. How do people disassociate? The Constitution is not in vacuum. There is the where ambiguity lies, there where the legislators come in. And I feel that's the reason why the Association Law of Liberia was statutorily created. So for people to associate, and you say, oh, they just have right to go their separate ways. It doesn't work that way. And I can sit in front of Copa and say, this is no politics here. And we differ with them, not in disrespect. All right, we respect them. They are honorable men on the Supreme Court.
Yeah.
But the law is the law.
Attorney Jensen, to your point, it brought this very important question to me. Councillor Jayweh,
Yes.
the right to associate in the case of the CPP, even though they had that right, they had to formalize it and legally for it to be deemed an association. So Jensen's point is, similarly to this associate, you have to go through a process that we didn't go through. The judge announced it. So the question is, you think the way that they associated was legal, was the right way to do? Mind you now, the CPP framework document also spell out how either one of those parties can leave.
You know, I think Attorney Jensen is confusing corporation law with contracts.
And you're so right. As to the corporate law on a vanishment, and I know what I'm talking about.
He is thinking about how corporation winds down, winds up. I mean, when you're dissolving the corporation, that's why he's trying to impute into contract. Corporation and contracts are two different things. They're two different entities, two different animals.
So how do people disassociate?
I'm not going to go into corporation, how they dissolve, because it doesn't interest me. Okay. I'm going to go into whether there was a contract. You know, when you sit down and as a CPP, ANC, Unity Party, ALP, LP, sat down and had brought in the room some brilliant lawyers. That's what I understand. Some brilliant lawyers to be able to help them to write their framework document. Something they thought would have been a contract to bind them, and choosing my word very carefully. Something they thought would be a contract to bind them. And so when they got through with that, somebody thought that we will not allow the marriage to ever be dissolved. So let's put in 8.52. Because there was not a contract, the ability for Unity Party and ALP to remove themselves out of an irregular group called the CPP was provided by law. Because you didn't have any agreement anyway. There was no contract anyway. So when you write a contract, I've written a lot of contract. I've advised a lot of clients about, how the contract should be. I even sit with my client to help them to understand that. The reason for that is that if the contract cannot be tested in court, for example, 8.52, if it violates Chapter 3, Article 17 of the Constitution of Liberia, Article 25 is moot, is inapplicable. It's not a shield.
Thank you.
Is it applicability?
Hold on, Mr. Sieh. Mr. Sieh, let me come in now. So from what I see here is you can withdraw. I don't think you can withdraw. I don't think withdrawing is the issue here. Is withdrawing with a clause that bars you or that stops you from being yourself after you withdraw. If they have, I believe if they have said when you withdraw from the CPP, you cannot fill a candidate in CPP's name, that is constitutional. But my question to you, Councillor Jayweh, is if 8.52 is null and void, does that render the entire document null and void?
Well, no, the entire document not before the court. What was before the court is 8.52.
But now 8.52 is unconstitutional, so the entire document is unconstitutional.
Well, here's the problem with that is that because 8.52 apparently, and again, I'm using my word very carefully, apparently lay out some process of how to withdraw. But because that process was illegally laid out, it was flawed. Therefore, or whether you were to withdraw informing the chairman of the CPP, it didn't matter anymore. Whether Unity Party signed, it didn't matter. Whether ALP signed, it didn't matter, because what you had is a void. In contract law, is referred to as a void contract, not viable. A void contract, something that started with on the wrong footing and ended on the wrong footing.
Same question to you, Anthony Jensen. If 8.52, I'm saying if because you don't believe so, if it is unconstitutional, does that render the entire document unconstitutional?
The Supreme Court, where I said the Supreme Court has created a lot of confusion into the CPP matter. And I would think either because of political reason, and I differ with the senior brothers here, who will sit here and don't want to accept the reality that political parties are registered in Liberia, and they file article of incorporation to associate. And you don't want to accept the reality that Article 79 gives the National Election Commission the right to do business with political parties. They set requirements. And those requirements is, go and read Article 79 if you have the time. Read it right now. There is a responsibility. There's a responsibility that is being spelled out, that is being given the National Election Commission. The CPP framework brought a collaboration together. If we use the correct words here, that collaboration has an intent. What are the elements of contract? Let's say, for example, and we'll see whether all of these elements existed for the sole purpose of Jayweh's argument. The elements that should be in the formation of a contract is that there must be an offer. Who offer who what? The question will ask. There must be an acceptance. Who accepted what? Who offered and who accepted? There must be a consideration. What is the consideration in this matter if this is a contract? The parties must be competent. Okay, we see that all of you guys are all, mature people who have properties all around the place. Okay, their subject matter must be legal. Mm-hmm. So they have a duty to respect the constitutional provision or the statutory provision that gave the National Election Commission to do what it should have done. If it is a contract, assuming another meeting that this is a contract, and I hold my view that this is an association for which Article 17 has been brought in. So the issue of contract should not be an issue for us to discuss here. Article 17 says...
Let me interject. Can a contract violate the Constitution? And if that is so, because not because we're in a contract, so but a contract can violate Constitution. Is that correct?
Depending on the provision that you will cite, I wouldn't say that as a lawyer to tell you say a contract can be in violation. Every contract, if there is a provision inscribed in a contract, and that provision violates the Constitution, indeed it can be considered as a violation.
Right. So in this case, if the contract says that if you leave this collaboration, your right to vote, I want to use vote. So if you leave this collaboration, you cannot vote in any election. That will violate the Constitution. I'm just giving an example.
But your example cannot be a factual issue for us to discuss here. The CPP framework...
So none of that use the word fee.
Fine. You want to feed a candidate. Then the National Election Commission that is charged with the responsibility says, we are not disagreeing or agreeing. All we are saying to you here is there is a framework document upon which we certificate you. Right. How to go about that is to come and raise an issue.
I'm saying just if that framework document violates the Constitution, even though you signed it, you notarized it, you did everything, but just in case it violates the Constitution, if it
violates the Constitution, indeed, the constitutional authority that has the right to say it violated it, they should say it.
That's the Supreme Court.
That's the Supreme Court. The Supreme Court has the right to interpret laws
and that's what they have done. The Constitution. And that's what they have done in this case. But
this is what I'm telling you. It's not just
someone not to run or not to fill candidate in the party's name, because political parties are set up to do just that. So if you tell them that, hey, because you sign your rights away, so leave your own with God, Supreme Court say, not so fast.
And this is what I want you to understand. When Mr. Jayweh to understand, when the members, the Chief Justice and the Associate Justices to understand that Article 17 that says you have a right to associate, and the right to disassociate is not an end in itself. It doesn't mean because it says it, so it's just binding. There are procedural steps that are being... What about what's happened with the ambiguities that exist within the Constitution upon which laws have been created? What happened to them? There is a law that says when you associate, in fact, there are procedural steps that set into motion how people associate. There's also procedural steps that say, how do you disassociate? Now, I ask my senior brother here, let's assume those people brought millions of dollars together in association. How do you dispose of those things? It's just because somebody want to walk away, or they might go away then before somebody says, oh, I kept my computer over there. I want my computer. But I put my $1 million is in the bank account of the corporation. I need my money. How do they get those things done?
Right.
In the process of disassociation and petition, those issues would have been handled, would have been resolved.
Right. Councillor Jayweh, please speak to that.
Let me correct my junior brother. The Election Commission does not have an authority as to whether or how political parties are formed. The election law provides that the election commission, the commissioners, are supposed to regulate the activity of political parties. They don't decide whether United Party will be United Party. They don't decide
requirements.
ANC. They don't decide whether the name of Liberty Party will be Liberty Party. Or I can get up tomorrow and say, Grand Bassa County, Sano County Political Party Association. We can decide that. So that's why the Supreme Court look at the attitude. Right now, I believe that the political parties, the Unity Party, Liberty Party, the ALP, must request that commissioners on the Election Commission be removed.
That's not an issue here, Mr. Jayweh. I
don't want us to go in.
Yeah, that's not an issue. Jayweh, I think you're making some mistake. Can you read Article 79?
I'm still speaking.
Jensen, hold on. Councillor Jayweh, I want to throw there at you if you don't mind. The ruling said purported, and you explained it very well that which is not is, but one thing is, right? And then they said it's in violation of statutory law. What statutory law are they talking about? Is it the election commission law? I mean, the election commission laws?
Yes.
All right. Then they also talk about public policy.
Mm-hmm.
What public policy this particular contract is in violation of?
The right to vote and not to vote. The right to form a political party. The right to form a political party, feed candidate as per the political party, which the right not for the election commission to declare the rights of Unity Party not to feed candidate in local country, the right of the violation of the election commission to declare that ALP cannot feed candidate in local country.
And it also says in violation of the Constitution. Which provision of the Constitution?
Is the Supreme Court referring to Chapter 3 of the Constitution, Article 17, the right to associate and not to associate. All the Supreme Court is saying that, look, when people get together and form an agency or a collaboration, that collaboration better be in conformity with the law, with the Constitution. It cannot say you cannot leave if you wish to leave. Almost, I think 6 months, almost 1 year, we heard the Liberty Party, the ANC people running from place to place, including some prominent lawyers that I know running with Article 25 and saying that there is a contractual protection under Article 25. That's true. But does it protect a void contract?
May I provide some information, Councillor Jayweh? I'm not interrupting you, sir, please. The CPP framework document lays out how one can leave. It did not arbitrarily say when you leave, you will not feed candidate. They said this is how you can leave. So if you choose not to leave the right way, then your right will be curtailed for this period. I know in law, when I'm guilty of something, they put me in jail or my liberty can be seized for a particular period of time, which is legal. So if this contract, your failure to leave the right way is curtailing your right to participate in the election for the period of time, how does that violate the Constitution?
So
only the court can do that, not individual.
So no. So 8.52 say more than what you just said. 8.52 say here are the procedure that you should follow to leave.
Yes.
Even if you follow the procedure to leave and you left, you cannot feed candidate in your name in the 2023 election until 6 months thereafter. It didn't just say when you follow the step, you leave and you okay.
I think you are impeding some 5 minutes of Jayweh where you see you cannot do it.
Back on
Let's read that.
Yeah.
You know, where's the 6 months they say you can have few candidates?
So let me read that, Dennis. If the constituent party, which has certified the dispute resolution mechanism, is not certified with the outcome, it shall file a resolution to withdraw from the CPP, signed and duly executed by 2/3 of its National Executive Committee. It being understood, however, that a party withdrawing from the alliance prior to the next presidential, legislative, and local elections shall not feed candidates in its name.
Correct.
So I said you were imputing some facts.
So if you
let you well learn, Jensen.
What you just read tells you even if you follow the that's why the Supreme Court struck it down. It said even if you follow all of the steps and you withdrew because you are dissatisfied, you cannot feed candidate. So
if I may ask him just a point, guys. I think this is interactive, right? Jayweh, I want to ask him a question. Jayweh, I think you have accepted in principle that the dispute.
I'm not Attorney Jayweh.
Okay, sorry for that. Sorry for that. Sorry, Councillor. I apologize. I mean, you earned it. But the issue is, you agree that dispute resolution, the mechanism exists.
Yeah.
And that should have been followed.
I don't agree.
You don't agree?
I don't agree. I just said that as long, look, that the mechanism, the steps you're talking about would have been perfectly legal. If there was not an addition to say that even if you follow these steps and leave, you can't feed candidate.
But the issue is, the National Election Commission said these people needed to follow the dispute mechanism. They have not done that at all. They have press conference, they say they have withdrawn.
Anthony, I don't think that's the contention here.
The contention, not even national election.
The contention is not about following steps or not following steps. What Councillor Jayweh is saying, even if they follow those steps, the issue they are contending is, if you follow the step, your right to vote and to be voted for is taken away. Correct. Even if you follow those steps.
Correct.
So following step or not following step is not the issue with the Supreme Court.
No, but
that's what happened when the Election Commission entered. The Election Commission entertained a letter from the ability wing with ANC and said that, oh, the 8.52 is a clause in your framework document. It's a contract. It binds you. ALP said no. Unity Party said no. We are going to the Supreme Court. And again, I must emphasize for my colleague to understand that administrative agency in Liberia, you don't file a petition for declaratory judgment before them. It is before a court, not before an administrative agency. Election Commission is a National Election Commission is an administrative agency that cannot declare rights or take away rights.
Mr. Jayweh, I differ with you. All electoral matters commences with the National Election Commission.
I got no dispute with
it
that.
Goes to the Board of Commissioners and then to the Supreme Court. So electoral matters like this one should have commenced with the National Election Commission. You cannot say it was a right to be decided by these people in the context of the Constitution that will spell out rights as you wanted to do. This is an association. There are issues following an association. There are issues that should be decided by the National Election Commission. So the right to be in a collaboration as they requested is a right that should have been decided by the National Election Commission. And anyone disagreeing therefrom, they should have gone to the Supreme Court.
Thank you.
You know, when you raise constitutional issue, I'm a practicing lawyer. Whenever constitutional issue is raised before a lower court, all of Liberia's specialized courts, all of Liberia's Sieh courts have, including administrative agency, have no trial jurisdiction. What do they do, or what they're supposed to do, is to refuse jurisdiction at that point. And
I agree with you. As a practicing lawyer, likewise, all constitutional issues are not answerable by any lower court. The Supreme Court is...
Attorney, I'm still speaking.
I just injecting.
So once the issue of constitutional matter are raised before the Election Commission or any of our lower court, only the Supreme Court of Liberia has the right to say this framework document as challenge is unconstitutional. The Sieh Court cannot say that. The Election Commission cannot say that. It is only the Supreme Court that says that. And the other thing I wish to add is you must address Justice Cllr as Chief Justice Cllr as an attorney at law. I want you to know that. You cannot address as Cllr.
Let me say this to you. I'm aware I went to a very good law school, and I can tell you for a fact, if I said Chief Justice Cllr, if I've said Justice Cllr, the word justice is understood in context of who has the Supreme Court of Liberia, Chief Justice, but he's a justice.
No, you said
right?
You said Kopo.
If I say Kopo, you know for sure I have said Chief Justice here. There is no, you know, this is
Gentlemen,
flying issue. There's a flying issue.
Anthony Jensen,
the Chief Justice is the Chief Justice. You know he's the Chief Justice. I'm not disputing that.
Jensen.
I respect each and every one of them.
Thank you.
So it's not an issue to raise, because this is some of the issues that were raised.
No,
those who listen say,
let's leave it at that. Let's leave it at that.
Even you yourself, I know you are a counselor. I'm an attorney. I'm not going to brag about that. The Chief Justice, if I say Kopo, it means I'm talking to a Chief Justice.
We get that. Let's
not everywhere I will speak, I say Chief Justice. If you're writing theses or articles, is that everywhere you will say Chief Justice?
Okay, let's leave it at that.
I have already noticed him, so I can discuss him as he is.
Attorney Jensen, do you believe this issue of 8.5 is a constitutional issue? Is it a constitutional matter?
My argument all along has not been whether it's a constitutional issue or not.
No, I'm just asking.
You are asking, and this is where when you are involved in public discussion, there are people who are listening. I don't want anyone to misinterpret what I say here. There are reasons why we appear on these shows. I have said one, that the Supreme Court decision has added more confusion in this matter. Why? Because there is an issue of what is in court, and there's an issue of the Supreme Court trying to handle and resolve a matter of 8.5. The issue that went before the National Election Commission is an issue of law. And the issue of 8.5 is anybody felt this is a constitutional issue, you needed to first go before the National Election Commission and take an exception thereto and run to the Supreme Court. You can't be in the street having press conferences. At the end of the day, you run to the Supreme Court. Now, the question you asking has a very important issue as to how this country move forward.
Yeah.
Election is next though, 2023. When people enter into association, how they enter association, how they leave association, it should be a clear laid down principles that we all should be speaking of here.
I agree.
So that tomorrow when it happens, people will not make reference to this case.
Right.
All right. I'll make progress on this.
Yeah.
Anthony, answer the question.
You still didn't answer the question, and you have the right answer.
Yeah, I have spoken enough about my position on this matter, and we can proceed therefrom.
All right. Ladies and gentlemen, we're going to take a short break. When we come back, we're going to play the SG tape saying that because of the ruling from the Supreme Court, all charges against Mr. Alexander Benedict Cummings are dropped, and he issued a big but, and he made a turn. That turn is symbolic of something. You will see that when we come back. Take a short break. Mr. Sieh, let's go.
Well, do we have the tape?
No, let's take a short break when we come back.
All right. Now, we will take that short break, folks. We will be right back.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Dennis Jah.
Welcome back to Focus on Liberia. We are discussing the Supreme Court ruling, and that ruling. But I want to remind everyone that when the history books of Liberia are written, the name SG Serenus Cephas will not be left out. I mean, this guy. So we're going to play a tape of SG Serenus Cephas talking about the impact of this ruling on the case of forgery and conspiracy, criminal conspiracy.
2023, no political party has been denied the right to provide candidate. No political party has suffered any injury. All they said that the forgery and the criminal conspiracy had occurred. So I have determined, as Solicitor General of this Republic, that the extent of injury suffered by the Republic is remote. Totally inconsequential. And therefore I'm speaking. Therefore inconsequential. As a consequence of that, I'm now trying to discontinue this trial and give Mr. Cummings a free change, but without prejudice to the state. So as we speak, that document is being filed. I have written significantly on the decision taken, and I will distribute that with all of you, all in your backs, and you will see the rationale behind the decision of the Solicitor General. And the key rationale is that the Supreme Court has spoken. Whether directly or indirectly, it has binding effect on all other persons residing within the Republic of Liberia. I can now take your question.
Councillor Sieh, then the question is the issue of a forgery. The ALP said that the signature page of the document was forged. How will you consider that also?
The contentious issue is whether the word resignation or withdrawal was used. Now, if you have a right of election and you withdraw or you resign, you suffer nothing absolutely. By law, you suffer nothing. The only victim in this case and the only involvement of the state is that there was a breach of public order. It's not a question of misdemeanor was committed. It was a breach of public order. And anyone who breaches public order will intervene.
Councillor Sieh, we still want to understand the issue of forgery. How do you discuss that?
I said the Supreme Court has spoken.
The Supreme Court spoke only on the issue of the alteration.
The strike, listen, you need to read the Supreme Court opinion. The Supreme Court struck section 8.5 subparagraph 2, which is a contentious issue. Then why are we still here?
But ALP filed for forgery and criminal conspiracy.
Did you hear the word strike? Or destroy section 8.52 to say it's illegal and unconstitutional?
Councillor Sieh, based on the ruling from the Supreme Court, and you said you drop all charges against Mr. Cummings without prejudice to the state, we mean the state can still call Cummings back.
When the need arises.
When the need arises.
Yeah, but for now there's no need.
If Cummings said no, he would not, and you want to
nobody has the right. If I'm standing behind you as a prosecutor, he knows exactly what to say without prejudice to the state.
But what does mean if you do this, why make for arbitration?
I reserve the right.
Why make for arbitration?
It means the matter is kept in abeyance, so Mr. Cummings can go about his business. He doesn't have to answer any more questions before this court.
So when would that be done?
It's been done as we speak. It's been done.
So Cummings is a free man.
Of course, yes.
It is a unilateral decision, or it's a decision that
I'm the one, the captain of the prosecution team, leading the prosecution.
You are not
the Justice Minister.
No, part of the problem with poor guys is that you don't understand. I want to bring small confusion. You're not a Justice Minister. When you are in court, under our law and practice, when you are in court, you are prosecuting the matter. You are the one, the authority leading the charge. When you are the commander of the war front, the commander-in-chief is sitting down, but you are carrying out. So, in effect, in the case, let me tell you, in the case is Wild versus Simpson. The Supreme Court in the 1930s said, if you are performing a conduct as a public official that reflects your responsibility, your conduct is construed as the conduct of the president. But if you take your hand and slap somebody, it can't be the conduct of the president. So there is a decision of the Ministry of Justice, Republic of Liberia.
Do you think?
What?
Do you regret asking
Regret what?
Do you think the Supreme Court ruling today is an unaccordion of the case?
Grossly to a large extent. I said, when the court rule, whether directly or indirectly, has binding effect on all individual residents within the borders of the Republic. Thank you.
So Cummings' right have been restored now?
Automatically restored. But without prejudice to the state.
So anyone may make that symbolic turnaround, but without prejudice to the court. I like that. Councillor Jayweh, how do you, Ansony? Let me see your.
And let's start with that turnaround. That was dramatic, but without prejudice to the court. That is my first question, and I'll start with Councillor Jayweh. This time, I'm not going to make that mistake that my man Jensen who said, Anthony, I'll be in trouble here because. So yeah, talking about that without prejudice. What does that mean for somebody like me who knows nothing about law? What is he implying there, Councillor?
You know, there are two. Under the criminal procedure law, the government may come to court. 18.1, 18.2, and 18.3. The government may come to court and decide to draft a criminal trial with prejudice meaning that the government will no longer come to court anymore and run after Mr. Cummings, if that's what he said. But he didn't say that. He said government is going to dismiss this case with the right to refile all without prejudice, meaning that the government could always come back to court if it thinks so. If it believes that there's reason to continue this case, the government may continue. And I think the other thing that came about, and the journalists were asking a lot of questions, was why did Councillor Sieh, and let me tell you another thing, Councillor Sieh is a brilliant lawyer. He's a brilliant trial lawyer. If you watch him in the courtroom, I don't like the drama that follows him, but I think he knows what and how to use the law in his favor very well. All Councillor Sieh said was he was prosecuting this case before the magistrate court, a misdemeanor, which if Mr. Cummings were tried and found guilty, he would have been sentenced to jail for 1 year. He said he was trying this case based upon the act that allegedly forgery were committed. And the contention of the party being that Section 8.52 was somehow incited into the framework document of the CPP. And if the Supreme Court struck that 8.52 down, obviously there's no reason to be in court before the magistrate court.
And what's the connection?
The connection is that if 8.52 is alleged to have been a crime committed by Mr. Cummings, Elisha Toll, and what other man, Senator Yetan. And this is what the ANC, this is what the ALP, the Unity Party, and Liberty Party were arguing. Then the whole issue had become moot, for which the Supreme Court saying that, Lord, this is not a contract. This portion of your framework document is order stricken down because you had put in a clause that is against public policy, that is violative of the law of contract.
Does that presuppose that was the alteration aspect of the allegation, Councillor Jayweh?
No, I'm not supposing. I'm saying that's what the SG said. He said, I'm just repeating what he said. He said that the reason for which he is filing a motion to dismiss with the right to refile is because part of the I don't have the record before me, so I wouldn't. It's a part of the contention of the parties had been that 8.52 was illegally cited or incited rather into the framework document, and if that didn't exist any longer, and parties are now free to go ahead and feed candidate of their choosing, return to their names, their identities, then he, as an SG, had no reason to be in court, and I agree with him.
Then the other aspect, Councillor Jayweh, is the issue of the forgery, which is more like a separate allegation from the alteration. So what is the connection there also?
So forgery and the alleged forgery, and because the case did not end, alleged forgery and an alleged alteration will be one and the same. Mind you, what we need to get clear and need to let the public know is that in all criminal cases in the Republic of Liberia, consistent with the Constitution and the criminal procedure law, it is the government of Liberia that prosecutes those criminal cases. Meaning that the SG can come to court in the middle of the case, as he has done, and file a motion or null prosecution, and file a motion to dismiss either with prejudice or without prejudice.
And Councillor Jayweh, something he said, my question here is the SG the sole authority in dropping this case, as he has said, because he illustrated that by saying, I mean, give an analogy, he is the commander at the war front, and so he can make that decision. Do you think he has that authority solely to do so, to make that decision as he
I
has
disagree with him on that, because when you go to court as SG for the Ministry of Justice, you say the Republic of Liberia is represented by the Ministry of Justice, and all attorneys employed within the framework of the Ministry of Justice. That covers all the lawyers. So the SG is correct that he had been the lead counsel in this case throughout.
Right.
But any lawyer working for the Ministry of Justice and with the authority to work for the government as government lawyer could come to court and dismiss the case. So the minister proper could have come to court. But what he's saying is that I'm the one who led this case. If you watch, and I don't know what it's like when people pay attention, but if you watch, you hardly see the Minister of Justice in court.
Never, except that he wrote and you're asking for evidence.
Let Mr. Anthony Jensen come in, so that give Councillor Jayweh a chance to turn his light on. Anthony Jensen, let's hear your take on the SG. And you know
it is serious.
Councillor Anthony, two of us wore red tie today to
That's true. No, but the SG, let me say here, the SG himself, he's confused, and he needed to go home, sit down, think of the ruling, juxtapose that with the facts of the case and the status of the case. And I think the councillor here is aware that the SG has started putting witnesses on the stand. And at this point, let me emphasize again the point of confusion and my position that the Supreme Court ruling has undermined the trial at the magisterial court. Even if trial goes on right now, Joma Jala cannot say anything contrary from what the Supreme Court has said.
That's why
the Supreme Court is to ensure that the rule of law, the exercise of justice, the purpose of justice is carried out. They have no authority. There is no constitutional authority as some members of the Honorable Supreme Court to jeopardize the trial that was ongoing at the level of the magisterial court. To hear Serena C4 say the Supreme Court ruling is binding on all authorities, when you know that there is a trial ongoing, when justice should be served.
Which trial are you referring to?
The Cummings trial. The Cummings trial at the magisterial court.
Okay.
To say right now, look, let me tell you something. In fact, all that SG said is just like some of the street talk. He's supposed to file a petition. The petition should be heard. The petition should be counter-argued.
Are you saying that those were two separate cases and so should have been looked at separately?
No, that's not what I'm saying either. The SG said the Supreme Court ruling impacts all authorities within the land to the extent where a case is ongoing, and then that case, right now, he has dropped charges. But let's bear in mind, he has started putting witnesses on the stand. The case is in motion. There's a judge presiding. The judge must have a decision, not the SG. SG is a party to the case.
Wow.
So for you to stand outside and say, well, right now, another person part of the case, one good thing he said, he had a smart in that point to say, well, I'm filing the papers. Because why? It's not what he says. This case is in the hands of Joma Jala, who is not the judge. Like Joma Jala will have to send citation. Joma Jala will not say and say, well, because Supreme Court has spoken, so the case is over. He needs to say something. If Joma Jala will say, well, the Supreme Court has spoken and blah, 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 so this and that, Joma Jala will wait on the parties to file a petition, the necessary petition or the motion. So we just sit here and say, SG, on that smart man, that clever man, he now says something that is legal, he's smart. Why he said just political noise?
Question.
He must find the necessary petition or the motion for it to be entertained, and that the parties will argue the motion before an action is taken.
I want to know, and this is for the both of you, and Jason, you start first. Yeah. Was this case held at this magisterial court beyond the legal and constitutional period, giving the mandate?
That's a very good question. That's a very, very good question.
Mhm.
I have said, if you read Rule 9 and the Liberian Code of Law revised, that's 25. I can state it right now, but Rule 9 provides cases, both criminal and civil cases, should not go beyond 30 days. There is a window of opportunity given for reasons why cases must be extended. In my opinion, those reason does not exist. This case has gone on for more than 6 months at the magisterial court. Now the issue of fraud. The issue of fraud is what it borders character, it borders criminality. The Supreme Court is not to sit out there and say, well, this fraud case, as far as we're concerned, is dismissed in the mind of the SG. Should Cummings go and sue them for tarnishing his reputation? If he just get and say the case is dismissed in the mind of Serena Seaford, no, you can't do that. That's not how the code works.
Councillor
Serena
Jayweh,
Seaford believed that all of this thing would be he write accounts and file a petition or file a motion to the court. So because of the Supreme Court decision, we hereby withdraw the case. Now the question you must should be asking that in this trial, witnesses are starting taking the stand. Is that at the point where cases can be dismissed by the government or by the prosecuting attorneys?
Thank you, Jensen. Jensen, thank you so much. Councillor Jayweh, the same question, and to Jensen point to is that how it's done? Because then they ask the question of what is the connection? The case completely different from what was going on with Cummings, even though they all talking about the same framework document, but that does not necessarily make the cases to be the same, isn't it?
We have two very distinct and separate cases here.
Excellent.
The matter that traveled from the Election Commission to the Supreme Court borders on the constitutionality of Section 8.52. And so the matter that went to the Supreme Court was just a constitutional issue. The matter that is before or that has been dropped, that was before the magistrate, borders on Liberia's substantive criminal law, the penal code, and the criminal procedure law, because the act of 15.70, forgery, was alleged. What needs to be understood, and I will hope the public can get that and don't get it from Attorney Jensen, is one, that in all criminal cases, the government of Liberia constitutionally has the right to come to court and seek a dismissal of the case with the right to refile or with no right at all. So it doesn't matter how many witnesses were placed on the stand. As long as the government comes to court and say, we, Your Honor, file, and in the magistrate court, you don't file a petition. So
motion.
You spread on the record of the court 18.2, 18.1, 18.2, 18.3 request the court to dismiss the case as prosecutors, maybe for insufficiency of evidence or for anything. But the right to dismiss the case is not with asking Mr. Cummings to agree or not to agree.
But what is the process?
The process is lawyer representing the state. And mind you, SG is standing out there and talking doesn't mean that he's the only lawyer. So there were lawyers in the courtroom as SG was in the outside there speaking. That file, I saw in one of the show today, file a motion to dismiss the case with the right to refile. So he didn't need to file it himself. He could have prepared a motion, sign it, and give it to a clerk to go to the court and file it with the clerk of court. The judge can assign the case if he wishes to hear argument, but the right to dismiss a criminal case is not in the prerogative or in the confine of the defendant that is prosecuted. It is the right of the state to say we don't want to continue with the case anymore without even saying any reason at all. And that's all the SG did was that I kept hearing that the Supreme Court decision honored the case downstairs. No. If the SG had not filed a motion to dismiss, the magistrate would be allowed to continue with the case. So he will not be disrespectful to the Supreme Court because the two cases are not the same. The mandate that I sent from that case to the Election Commission that the 8.52 is unconstitutional got nothing to do with the magistrate.
Thank you.
Well, it is the SG that is making it that way because that's the basis of his argument, isn't it?
Yeah, well, all the SG says that, look, and again, I need to go back. The right to dismiss a criminal case, no matter how many witnesses are being placed on the stand, is vested in the state, not in Mr. Cummings, not in the client of Councillor Jayweh, not if Councillor Jayweh are representing somebody else. We don't have the right. I cannot go to court as a private lawyer and file a motion to dismiss a criminal case. It's only a government lawyer that does that.
Thank you.
Councillor Jayweh answered my previous question whether the case was held beyond the legal or constitutional.
Oh, okay. Look, the law is reasoning. The rule cited by Atty. Jensen talks about 30 days. That's the rule of the magistrate court, the rule of court governing the magistrate court. But lawyers that appear before the magistrate, the prosecutors and the defense lawyers have legal responsibility. That responsibility includes if I, as Mr. Cummings, go to Mr. Cummings' lawyer, and Mr. Cummings' lawyer felt that this matter will continue beyond 30 days, what they should have done was to summarize the magistrate before Criminal Code A, that the rule is being violated, and that the matter has been before the magistrate court for more than 30 days. The circuit judge will have either instructed the magistrate to proceed otherwise. The failure to do so is constitute you acquiesce, you agree with what happening. The magistrate will not dismiss the case by himself to say, oh, more than 30 days now, so I'm going to dismiss the case. It's the Cummings lawyer who sat there when the Solicitor General, that's why I say he's a smart lawyer. The Solicitor General went ahead and subpoenaed all of the witnesses in the presence of the Cummings lawyers. You know how long it takes for you to even go find the witnesses why was subpoena issue? So the Cummings lawyers sat there and agree with violation of the 30 days you're talking about.
But if I may just inject that, Senior Counsel, the issue here, every court, even in the United States, we have been told that when it comes to speedy trial, speedy justice, unnecessary delay of cases is a serious matter. All judges in the American here, people are monitored and people are sanctioned for these things. Joma Jala, as a magisterial court judge, if the statute says 30 days, he set the trial process. He, in fact, he should have had a conference meeting with the parties to say, I am the person holding the gavel here. This trial is not going to go beyond 30 days because that's what the statute says. And because the statute says it, your witnesses and what all you're going to be doing, we all will live within the confines of the statute. Now, let me leave that out. That has gone. I mean, no one asked questions, but you raise a good point. It is true that lawyers should have filed a necessary motion, which I agree with you. It is a right of all of them. In the same vein, the obligation is on the judge. He should not be the violator of the statute. But let me go down to the issue of the Serena Sieh's case to say the case is being dismissed. You know why the case cannot be dismissed at the point where witnesses have testified? He said when he does that, in the future, he can bring Cummings back. Wouldn't that be double jeopardy? You are a senior lawyer. Can this case be dismissed at this point? And later on, you say, oh, come in, no, we get evidence, you come back. Is that why we are suggesting? Is that why we should tell our people? Is that why we should tell young lawyers? That anytime at the point where witnesses are understand, we dismiss the case. When you dismiss the case, can you come back? Can you bring Cummings back? Wouldn't that be double jeopardy? What should the judge say? That's what I said. In my opinion, Serena Sieh just caused noise. He know when you go sit down, you're going to think properly. The motion that you will file, he will give you a serious thought as to the count of those motions. So I wouldn't even want to give credence to everything he said because it's outside of the court. But the court has its own drama, and you know that. That all that he said, and you said you agree with him. And that's the only reason why we argue the points here, because you say you agree with all that he said.
Councillor Jensen, is your contention with SG on the process, or you are saying he doesn't have the right to dismiss the case?
Dismissal of the case is a right accrued to the prosecuting team. But the issue of law that should be of concern is this is a criminal case, a fraudulent matter that borders the character of Cummings right now. If the government dismisses the case at this point, couldn't Cummings sue them for damages?
No,
maybe the senior lawyer can address that for me.
Right, we'll come to that. But
okay.
I'm just
and the importance here is, look, I'm aware that the prosecuting team can dismiss a case at any time.
Right.
But
so what's your issue? What's your issue?
My issue is, and maybe the senior lawyer can say that when your case is dismissed at the point where witnesses are taking stand, the case has gone halfway. The judge, in fact, would make a determination as to whether he would dismiss the case at that point.
No. Are you saying if the SG dismisses the case, the judge have to agree or not agree?
Oh, there's a motion filed. Yeah, the judge has to agree. Okay. It's not just because you say he filed a motion, the judge will have to make a determination.
And what would be the grounds to what would be the grounds to refuse?
Well, that should be within the purview of the judge. The judge can agree with him, or the judge can disagree with him, based on the judge's own understanding of the law. Or maybe if the judge agrees with him, it's okay, based on this, we rule that this has happened.
And so,
maybe Jayweh can tell us now.
Yeah, so Jayweh, given what Jason is saying, at this point, now that the case has been withdrawn according to SG, is it now left at the discretion? Is it now left at the discretion of Judge Joman Jada, who has been presiding over the case, to accept and not to accept? Isn't the withdrawal, as Serena Sieh has said, doesn't it bring this whole case to a close?
You know, the motion ends, let me put it in a very common way. The motion Attorney Councillor Sieh's file, SG's file, ends the entire trial with the Cummings. Cummings case has come to its conclusion. What the SG did not say, and no one can infer it as to what he said, is that this matter is dismissed with the right to refile. He didn't say I will bring back the same case. He said with the right to refile. You could refile anything. You could refile, what do you call it? Theft of property. You could refile any criminal matter. Mind you, all criminal cases rest in the authority to prosecute criminal cases in Liberia is with the state. And if it would be crazy for SG to file his motion on the record in the magistrate court, because you don't file formal plea in the magistrate court. And then Mr. Cummings, people get up and say, no, we disagree, Your Honor. We want this case to continue. But the magistrate does not determine when the state decides to drop a criminal case. That's why Dennis asked the right question. Are you saying that the SG didn't have the authority to dismiss this case? The attorney said he had the authority, so the matter closed. So whether the judge agree or not, the government who are prosecuting the case, they say, look, we're not going to prosecute the case anymore. And the law requires that they do not even state a reason.
Thank you. And Dennis, this is my question on the issue of legal injury.
Hold on, Mr. Sieh.
All right, go ahead.
Let me announce this question. We have less than 25 minutes to close. So if you want to join the conversation, the call here. The number is 605-313-6004. The code is 791-403#. And we have callers already available, but I want us to look at the options for Mr. Cummings. He has said over and over that this will have consequences. So let me start with you, Councillor Jensen. What are the options for Mr. Cummings if the case is dropped?
There are two things that I see in this entire case. The first one is political. Cummings as a political person, and sometimes I see that in my way, I've been in the circuit of government. I know people do a lot of discussions. And the way the SG is speaking, if I look at it from a political point, I would think that, people can come in the theater like their enemies, and in the night, they all make their calls and all of the stuff. Political-wise, Cummings could say, well, this is politics. Election is almost here. I have so much thing to do. Let me just proceed with my case or with my political activities. Another thing he could say, this case has injured me. Everywhere I go, even though the case has not ended, the people say they are dropping the case, whether he will see it as, someone who did not commit a crime, but politically somebody will be saying that coming is a role. So can Cummings say, look, this case as I'm concerned, I'm done with it. It has taken too much of my time. I think, and this is not an advice to the Cummings group, they have legal minds to advise them that they could decide, all right, if the state dropped the case to say, well, I have been injured, I'm going to sue these people for damages. That could be another route that the Cummings could want to go. If Cummings went that route, what's going to happen? Well, it's all about, he's a senior lawyer, he can tell us whether Cummings get a right or not. I know Cummings has a right. All
Thank
right.
you.
That's one reason why I think the judge, Joman Jala, when I say fine motion, I don't mean a written motion. You can go to court, you say, I represent A, B, C, D. Okay, today I'm here, I have a motion to file. After you have announced yourself, you say, count one, my motion is today. Dismiss this case because the Supreme Court has spoken. Count two, this case, we all wanted to prove this, and this has happened. But dismiss this.
Thank you.
And that oral motion is filed, the judge make a decision.
Thank
I don't
you.
know what the senior lawyer is telling me, that just by saying it, without a motion, without a judge's decision, that means the case is dropped. I don't think so. If that is his opinion, I disagree with him. That when motions are filed, not necessarily a written motion. An oral motion is filed, the judge make a decision.
We don't know. It might be filed already. Councillor Jayweh, same question. The option for Mr. Cummings, we have plenty of people already lined up. And in this case, we see that the Unity Party is free to file to field a candidate in the local election. We also see that all charges drop, hopefully. So it's a win-win. But let's see what are the options there quickly for Mr. Cummings, and if this is truly a win-win, or if somebody really got one bigly than the other.
Councillor Jayweh, allow me to add there. It's basically the same question, but I will give some flavor to it, then you can beat it down for us. According to Sieh first, he said the only thing that happened here is the breach of public order. As an ordinary man, you have to explain to us what that means. Now, let me come to what Dennis said. Now, to what Dennis said, he said that people resign or withdraw. It does not injure anyone, according to him, legally. Is he right that no one was injured or is injured in a particular case? And then that question, what are Mr. Cummings' options? And can Cummings sue him for wasting his time in court?
Let me answer the question whether Cummings can sue him. No, Cummings cannot sue him because he was representing the state. Cummings may choose to sue the state, not the attorney, not the solicitor in the court, because you are pretty much representing the interests of the state. That's why he's hired as attorney
He said the only thing yet is that a breach of public order. What is public order, and what was that breach you were referring to?
You know, the Solicitor General or the Republic of Liberia is responsible to maintain law and order.
Mm-hmm.
When a crime is alleged to be committed, breach of public order will include anything that was set apart law and order. And meaning that the confusion in the CPP could have caused public unrest in Liberia, and therefore he chose to review the evidence, issue a writ of arrest, have Mr. Cummings and Senator Yetan and Councillor Toll arrested and brought to court and filed a bond. Whether it's true that by inciting into the framework document, section 8.52 could have led to public disorder. That's another thing. If you follow very keenly, and I said I was, and if I advising Ambassador Boakai, I would not have had me to make such statement. There were statements made that if the Lofa election were not in it, it would be in it. Did you hear that? There were speeches made. There were people from the Unity Party who said that we will be part of this process no matter what. And that 8.52 cannot be used against us. I thought they were waited to go to the Supreme Court. And I always believe that the Supreme Court is going to strike 8.52 down because they were wrongly written. And Supreme Court did so. So today, I understand that happened. I think the SG is saying that he went to court in order to prevent public disorder. There could be ANC people and the Unity Party people start to fight on the street. I think you saw some of that at the Election Commission. Demonstration all over the place.
Thank you. Let me read just a few comments from our viewers here. This one from Crystal. Based on the ruling, can we say that there was never a legal document at the NEC? So the one that was filed with the NEC, do we say that was illegal document? That's the question from Mr. Crickle.
So what the NEC had is a framework document that was filed by Mr. Cummings and his team. So until the Supreme Court today ruled, mind you, the Supreme Court did not strike down the entire framework document. It didn't do that.
But that's what it means, right?
Well, in essence, that's a cross of it's almost like you buy the vehicle and remove all the tires from under it. So what vehicle do you have?
So Jayweh, now we just come in and the Supreme Court has struck this document. Why? Because Supreme Court acknowledged and said these people withdraw. Their decision to withdraw is a constitutional right given to them. If the Supreme Court said that these people are signatories to this document, it's not just that 8.5. All right? They are signatories to the document. So if they withdraw from there, what happens to the document?
It's not involved.
Not involved.
Of course.
So we cannot play with this thing. And that's what I said Africa has caused more confusion.
So meaning that the document that is right there with the NEC is
void.
So
if it's void now, the question with the additional issue with us
cannot take a seat.
So let me go further and say,
yeah, sorry, you can go ahead.
The Election Commission, not the Election Commission, or the Supreme Court, striking down 8.52, which we said all along that was unconstitutional. The party may decide what they wish to do. They may decide to go back and say, okay, now we'll go back to our document that was never, there was no 8.52 in it. Or they may decide, the Supreme Court said they may choose to do what they wish to do, which include feeding Kennedy in local content. But factually and realistically, the CPP was dissolved from the day it started, including the 8.5 group. So
say that.
We just left.
You have arbitration and dissolution clauses, provided those clauses are inherently legal. That's an easy matter to say, Admin Sharif. All right, we have a lot of callers here. We have a lot of callers. So callers, please, I think we have like 15. So 1 minute each, we'll have 15 minutes. Then we are still above our 2 hour. Let me start with Mr. Elvis Morris. Mr. Morris, you are live. Quickly to the issue.
Yeah, Mr. Jad, thank you so much. And I just want to praise the platform real quick before I get to my comments. I just want to say thank you guys for having the presence of mind to even bring on legal experts to, pontificate on this issue, unlike some other platforms who just think they know it all and try to talk about things outside of their scopes. But quickly, I just want to say, let the irony not be lost on us that the United Party wing of the CPP was actually, the ones who actually exonerated Alexander Cummings, because this motion was filed by the United Party wing about the candidate being, able to contest in, local county. And that in turn ended up being the one that freed Mr. Cummings from this trial, or from this case. So let us all have some hope that maybe they will see, that maybe by divine intervention, they all were able to be clear and maybe they can come back together. But again, thank you so much for the show.
Thank you.
This platform is great. We really appreciate it. You guys keep up the great work. Thank you.
Thank you, Elvis. Let me go to Dr. Batum Cllr.
Yeah, I just want to say that in Liberia, for some reason, we major in the minor in the major. What do I mean? Our SG took a case that should have been a civil case handled by a judge and probably throw out what seemed to be a contract that was null and void based on whatever reasons, whether I didn't sign it or that's not my signature or that's not what I agreed to something where they put in so much money, so much resources, so much time and energy just to prosecute our political leaders. We need to stop this. And those in the legal field in Liberia, it makes us look so bad. I don't have any impression of the SGB, some well-known lawyer that knows everything and he's so great at what I know. He just pontificates. He talks a lot. He's braggadocious. He bluffs. But I can tell you one thing. That man comes to America and you look bad, because in America, you don't do what the SG did. I mean, it's a case between individuals, a civil case. It had no business going to the level where it went to. It's a shame, man. We need to stop that. And legal minds that know better need to speak up on that. Have a good day.
Thank you, Dr. Cllr. Let's go to Lawrence Yanu. Lawrence Yine.
Yes, Lawrence Yine. Thank you.
Thank you.
Before I say anything, I would like to say, Councilor Jayweh, yes, leave it because Anthony Jensen has now been calling the titles, and these are things that you guys fight for. So just leave it. My concern has to do with Article 1 and 2 of the Constitution. You guys should look at it. And even the Article 17 you are talking about, the last part of it, it says that you got a right to refuse to associate in a political party. Then Article 25 again. Article 25 also says there should be no law that will impair with the national law of the land. All right. All these rules are there. Anthony Jensen is looking at it. You also blame Joma Jala delaying a case. Is there a motion on the case docket for a dismissal for the judge to deny? They got statutory period for the case. And we will use the lawyers to spread on the minutes of court a submission for dismissal for a Why should you blame the judge?
Thank you.
Anyway, other guys got to come in. Thank you.
All right. Thank you.
It sounds like a just the piece.
I know, right?
Let's Mr. Kesali Double.
Yes, sir. Thank you, Mr. Jai, and thanks to the platform for the night.
Thank you.
Mr. Jai, there's whole noise about this case and everything that will be there. For me, I would want to shift all of my blame on the National Elections Commission.
Correct.
The Election Commission is gone with the authority to be able to verify every constitution that comes to it from political parties. Let's play the devil advocate and say this identical portion, 8.5.2 was in the PPP forward document. Why didn't the Election Commission or the legal mind at the Election Commission didn't know that the identical portion was a contradiction to the Constitution? Couldn't they warn the people in time ahead so that we don't have reached to where we reached at this point?
But Kesali, what's about the lawyers for those political parties?
Granted, I agree they were lawyers, but the Election Commission is gone constitutional with the authority to do that.
Okay.
To verify every instrument that comes to them from political parties. It is there. It is in their law. So didn't they do their homework and allow the reach this far? I think the Election Commission has a serious problem, and I hope we can be able to discuss them and make some possible some changes in that place with this done on earth. Come 2023, we might see ourselves into something very, very clear.
Thank you. Thank you. Let me call someone from Edmonton in Canada.
Yes, hello. Yes, hello.
Yes, your name, please.
Reverend Daniel D. Dennis.
Go ahead, sir.
For Canada.
Go ahead, sir.
Yeah, first of all, I want to greet my dear friend and brother, Councilor Jensen. Anthony Jensen. Jim Jensen and I, we were housemates. Right, they were living on our house right on the bypass there. I think he knows me. They used to call me Didi.
Oh, Didi. Okay, I'll call you.
Yeah.
Yeah, my dear brother, I know you very well. We used to take by around the porch, eh?
Yeah.
I know those days. It was you, Nobody Wonder, and other guys. I mean, we talk from here.
Yeah, we were ELU at the time we were still in school.
Okay,
so, I just want to throw this in. I don't know whether we really have legal minds in Liberia.
Yes, we do.
Or things that they do, or decisions they make. I mean, it is deliberate. I don't know. Because this was no case for them to take about 3-4 months.
That politics.
It's something being politics doesn't mean you should drag somebody in the mouth. You see, so my problem here, I have been listening to the program, and I want to give kudos to the two legal minds over there, and my man Anthony Sieh, because I usually watch his program. I mean, he analyzed.
Man, that guy's good.
I mean, we need to do something about that country. The legal minds that are there, they don't really do what they ought to do, or maybe things that they're doing it deliberately because of money. They have no right.
Just conclude, Reverend. We got more callers.
All right. I just want to thank God that the case no more, and the Solicitor General has done what he wanted to do because he was acting upon order as far as I'm concerned. So we thank God that Cummings is no more in that mess, and it is all. Finally, Mr. Jensen, you need to call me.
Yeah, right.
I will call you.
Okay, I will give your number to him.
Okay, thank you.
All right, thank you.
Let me bring our last man here. Thank you. Let's get to Mr. Aliyu Kamara Aliyu Samba Kamara. Aliyu, you alive?
Thank you so much. You know, let me just tell you first of all why I'm a fan of Councilor Jayweh. You see, academic credential without common sense is like a barrel sitting on top of a well empty. When you have academic credential, the foundation, the thing that solidifies that credential is common sense, and Councilor Joel has a lot of that. Let me address a couple of things. Somebody said, why would the Solicitor General try the case at this time based on the Supreme Court decision? It is simple. The reason why Jayweh took this case to court in the first place was because of Article 8.52 of the framework document. He said that was enshrined into that framework document unknowing to them. That's when you use the word nefarious and all of that. Okay, you might use the word fraud and all this, but the point is that article is the one that is under question. No constitutional or legal body in the country is above the Supreme Court. The Supreme Court come out and say that particular thing that is in that framework does not exist. In fact, this whole thing is not a contract. You still really, common sense, do you still really expect Serena Civil to dress in a 3D suit every day as they go over there when the thing actually doesn't make any difference? So people must look at things from a very common sense. There's somebody saying in there talking about why would Serena Civil drop a kid? He does not have the authority to drop a kid. Let me just forget about whether or not it is government. Then I take you to court. I sue you. I say you stole my sneaker. We go to court the first day. The second day, the court said for us to go to court. I will file a complaint and I go to the court. I don't even have to send any petition. And I go to the court. Don't you think the court drop the case, my case?
By example, you are hearing contempt.
Whatever, man. No court will force me. I will drop my case. No,
But you don't go to court after sending down a case, the court will drop your case. Pause, man.
No, first of all, let me just say this. So I'm
you just leave the man, let him go.
No, let me just say this. I never went to law school, but I'm just saying, listening to you a couple of times on Focus on Liberia, I can beat you any day.
I agree with you. I can give you everything.
Myself.
I agree.
The Supreme Court gave 4 different articles. 4 articles for which they trash this whole thing. They gave Article 25, they gave Article 17, they gave Article 78 and 79. You come up there, he wants to use the same 79 to support Arizona Cummings. When the Supreme Court clearly read Article 79, that was violated by that particular article.
You see, you're saying something differently. The Supreme Court didn't talk about 79.
You understand what I'm saying? And I'm not kidding with you. I can beat you in any court.
Thank you.
Oh, thank you so much.
I wish you go to law school, you learn better because coming over there, you will know who you're talking to.
All right.
Okay.
Attorney Jensen.
On a very serious note, let me close on let me answer these questions. There are a few questions I jotted down. Cases, bad cases. We all encourage political parties, individuals to take interest in the rule of law. It's better to fight in a courtroom than taking guns. So we encourage everybody to join the exercise of going to court. If you are injured, if you are hurt, if somebody blow you or somebody take a property or whatever the case is, it's good. You go to court. There's nothing wrong with that. Political parties going to court is healthy for democracy. On Article 17, I have said already, Article 17 emphasizes the right of individuals and political parties to associate and disassociate. And my argument here is that to associate, the framers of statute, our founding fathers, decided that, look, this is ambiguous. How do people associate? So they went and created a law. That law spelled out how people do what they need to do to associate. So my contention, my argument, or my disagreement with the Supreme Court opinion is that to scratch or delete or ask the parties to forgo 8.5 of a National Election Commission to consider the CPP or Alexander Cummings case, to delete that 8.5, there are two things I'm seeing 8.5. One, it's not just the right thing that was done. Somebody is saying somebody incited that creating a criminal attitude. Somebody says somebody criminally did something. They incited this in the framework document. So it's not just that it's in the framework document. Someone say somebody did it illegally. So that's an act of criminality. All right? So the court says that 8.5 is unconstitutional. If it's a constitutional issue, the Supreme Court has the right to interpret and say whether that law violated the Constitution. But if people are alleging act of criminality, that case still remains. Cummings is being accused. Cummings is in court because of that. The Supreme Court cannot sit up there and dismiss criminal cases. They cannot. So if it is a constitutional violation, you have stated the Constitution, the framework document 8.5 says is in violation of the Constitution. Supreme Court has the right to interpret. But the case at the magisterial court is not a constitutional issue. It's a criminal issue. Somebody says...
Attorney Jensen, just point of correction, the Supreme Court did not dismiss any case.
I'm not saying they dismissed the case.
Okay.
I'm saying to you, their action affect the case. Okay. It undermines the case. It undermines the trial at the level of the magisterial court. Because the broader point is, Cummings has been accused of inciting this clause within the framework document. The parties are saying they are not aware of that. The Supreme Court is saying, as far as we're concerned, this case, this thing is not consistent with the Constitution.
Are you suggesting that the Supreme Court should not have given a ruling because there was a matter in court?
Yes. The Supreme Court at this time, her ruling undermines the trial at the magisterial court.
So they should
even though the Supreme Court decision was being prayed for by a party and needed not to make decision.
The Supreme Court talk about public policy, right? Public policy is looking at all of the matters. There are elements of public policy. They talk about one, somebody referred to war, somebody talking about whether we're going to have shortage of gas, we're going to do this. All of those parties that come to public policy, the Supreme Court would have been looking at all of those things. So the case now at the court, you and I are discussing, Serena Seaford is discussing.
So they should wait.
The Supreme Court has authority. They had authority. There are cases that are still in our Supreme Court up to this time. Jayweh is aware.
So for this one, they should wait until the case is over.
There's a criminal case that attached to this case. The Supreme Court shouldn't have ruled at this time. That's my opinion. Why? Because the Supreme Court, get me right, the Supreme Court has the right to do what it did. But I am saying because they did what it did, it affects the trial, the criminal trial at the magisterial court.
Anthony Jensen.
You know, I need to come in. I'm sorry.
Yeah, I'm getting confused there.
This is deadly. This is outrageous. This is actually understanding nothing about how the court system is run. A magistrate court has a case before it. The Supreme Court is supposed to wait.
You're not getting a
different case.
No,
hold on, Councilor Jensen. I mean, Anthony Jensen, hold on. Sorry.
When you say that, I'm wondering whether you ever practiced law in Liberia.
I did.
Because
Councilor Jayweh, let's go to the case.
I did.
The magistrate court is a court of first instance.
I agree.
The two cases, the criminal case before the magistrate court is not connected to the constitutionality of the issue that before the Supreme Court.
All I'm telling you, Jayweh, is that case undermines the trial that's ongoing. That's my point. Let's get it clear. Let's get clear because I know you're going to be quoting me tomorrow. So I will interject. Let me say it again. The Supreme Court decision undermines the trial that was going on at the magisterial court.
So what is the Supreme Court supposed to do?
The Supreme Court, the Chief Justice and the Associate Justices, they control the administration of justice in the Republic of Liberia. They would have made a decision as to whether their decision would have affected the trial at the level of the magisterial court.
But that's what it's supposed to do.
So what would the Supreme Court do? Wait for the magistrate court?
The Supreme Court had a decision to know. There are cases that are pending up to this time that have been over there on the docket for a long time.
Also wait for the magistrate court?
I am telling you, the Supreme Court has the right to know whether that decision would have influenced the decision of the trial at the magisterial court. You think the Supreme Court don't know that?
Then what?
If the Supreme Court knew that, the Supreme Court could do what they needed to do. If they did, and then we are here to tell you that their decision undermines the trial at the magisterial court.
So what would the court have done?
They would have done anything they wanted to do. They understand that there's a trial ongoing. There's a criminal trial ongoing surrounding this identical issue. The fact and circumstances, the parties involved are all the same. So the Supreme Court has ruled now. What happened to the magisterial court? You're not looking at that.
All right.
What happened to the magisterial court?
Jensen, we have to leave it there.
I don't know
Mr.
what
Jayweh, please end your thought there. Time is fast spent, please.
It is. I think we need to close, but it is striking to me that, and Attorney Law will argue that way, this way. The Supreme Court is the highest court of the land. The cases we're referring to, they are not related at all. One is criminal, and the other is a civil matter questioning the constitutionality of 8.52. Any lawyer that said the Supreme Court should have known to wait because there are other cases there, they are not decided, is saying that the magistrate court supersedes the Supreme Court.
That's not what I'm saying here. I can't be a lawyer and tell you that.
And I must make it clear for the public that in Liberia, the Supreme Court is the highest court of the land. The magistrate court is the court of first instance. It answers to the Sieh court. It doesn't even go near the Supreme Court. It answers to the Sieh court. So the Supreme Court doesn't need to wait for the magistrate court. It's a travesty, absolute travesty to be able to do that.
Thank you.
This is bad.
Thank you.
And let me say this before you continue. I mean, just a point, because he just told me. I have said this. I understand the power of the Supreme Court. And my position here should be very clear. There are people who think that when you make analysis of Supreme Court opinion, you're committing crime. I have said here, the Supreme Court had the right to make any decision they had to make. But my position here is the parties involved at the level of the National Election Commission are the same parties at the level of a criminal court within the magisterial court. Decision made by the court, by the Supreme Court, has an impact. You heard Serena Sieh emphasizing here that because the court has spoken, it has a binding effect on the parties, including the magisterial court.
We agree with that.
Don't we ask the question, why is it that the Supreme Court, knowing fully well the Supreme Court could not make a decision that their ruling would have affected the trial at the magisterial court? Is it wrong for a judge, for a lawyer to say that?
Thank you.
To ask a question?
Thank you, Anthony Jensen.
When you commit a crime?
Time. We have to leave here quickly.
Let me get a few more comments here, and we appreciate people. Master Collins say, FOL is the best among the rest. Professional opinion matters to discussion, unlike some biased media, Liberian Network. Keep up the good work. We say thank you. Elder Joseph Kokro say, FOL is the best in terms of balanced presentation of all major trending issues of the day. Kudos, FOL. We thank you all. Keep your comments coming. We appreciate criticism. We also appreciate commendation. Gentlemen, want to say thank you so much for coming at such short notice. I know we took a lot of your time. We want to appreciate all our callers, those who made comments and those who watched, and even those who are going to watch later on. Keep it here at Focus on Liberia. Before we close, or before Mr. Sieh come in, we have some commercial business here to take care of. These are the people that are paying the bills. 15 Gate Incorporated in Upper Cowell, Moserado County, has 100% all ladies and men fashion design. If you want to get in contact with this group, come and shop the best in men and women clothes and footwear. The cell number is 0775-165-416 or 0880 026218. If you want to call them on WhatsApp, contact 775-165-416. Also, Councillor Tiawan say Gonglo, the friends and supporters of Tiawan say Gonglo, they are calling you to join them for their activity, and that is Saturday, June 4th, 2022 at 6 p.m. Join the live discussion that will be in Fargo, North Dakota. For more information, contact Kelvin 701-540-313 or Jayweh Kent at 774-253-4472. Next week, Detour in the house. He's going to be talking about his musical career and his new album that will be dropping on June 25. Mr. Sieh, you heard the legal argument.
Dennis, I heard the legal argument. Even though Serena Seaford left a window open that they can come back, and I continue to tell you this case has been political, even though there's been illegal. It's like the legal aspect is being used as the conduit, to carry on a political fight for the necessary dividend so that one can make it to 2023. But it looks like it's coming to an end. Both sides are happy. I mean, Dennis, can you imagine opposition people are dancing in the street? When I saw them, like, really. But this is what I want Councillor Jayweh to end with, because Councillor Serena Seaford, he put a lot of drama. We heard him saying, well, this case is over. Cummings is guilty. What is left now, is a decision for him. He said, what is left now is for the man to go teach like G.W. Gibson. And this is the man that someone saw in no time and say, well, I'm dropping the case. And the Supreme Court decision came at the time he was actually looking for what option to use to just end this case. So I'm just curious what Councillor Jayweh made of all those things this man has said. This man have announced a verdict as though he were the judge. What happens to all that?
When you have a trained trial lawyer in court versus people who want to be lawyers who are taken for a ride, you have those things.
Wow.
Quite frankly, Councillor Seaford had no match in the courtroom. So all of the things he did, nobody was stopping him at all. And nobody would, give me, as a trial lawyer, why would you allow the state to subpoena its own witness, 34 of them? Why? Because of clear incompetency. Because of clear incapability to be able to defend Mr. Cummings. That's why the case lasted for 5 months. Every time Seaford made those kind of statements, the Cummings lawyers sat there and did nothing.
Like what?
For example, while the matter is in court, the Solicitor General came out one time and said, I will have him go to G.W. Gibson or whatever school, Matilda Newport Street to teach, Matilda Newport Junior High School to teach.
Carry on community service.
While the case is in court, you are precluded, you are barred from making prejudicial statements. Did the Cummings people file a complaint before the magistrate for investigation? No. Did they summarize the magistrate for the type of ruling that were being made that kept the case there for more than 30 days? No. So Seaford was the lawyer in the court and controlling every other thing. But if Seaford had a lawyer competent enough to match him, the case would not have gone for 5 months. You have somebody like what you Councillor Orochi Gu as one of Mr. Cummings' lawyer. You kidding me?
Does he not know a thing?
What's that?
Does he not know a thing about the law?
My goodness, I would never now want to quote if he's even. I will even hire him. There's a difference between somebody who speaks politically and someone who is capable to represent you. Your reputation as a person is on the line. You are alleged to have committed a crime. You send a politician in the courtroom? Or somebody who put earpiece in her ear and running around as a lawyer?
Dennis, they are talking about your friend.
Yes, I don't want to be here in contempt. That guy.
Yeah, please. That is
but that's
true.
why the case stayed for 5 months. Yeah. I'm sorry to say, but that's why the case stayed for that long, because people were actually talking politics and not the law.
That's true.
Thank you. Anthony Jensen, yesterday we were discussing the forensic audit report that Mr. Cummings commissioned. Do you think it had any bearing on the case, or is it because of that, since he was exonerated that the case was, I mean, do you see any connection here, or you will say, maybe he shouldn't have filed now, he spoiled his money and the case is dropped? So, sorry, Councillor Anthony, unmute yourself, please.
No, there is something that I think other lawyers should begin to think about, doing a lot of in-house attending in-house conferences and learning a lot about what happens when it comes to cases like the issue with Cummings and the CPP. It had a political dimension. Anyone who has listened to me in this matter, my position all along has been, look, the CPP conflict came as a result of leadership struggle. Today, we see people rejoicing in all of those things because they never had a clear, defined legal issue to take to court. So in this kind of a situation, you will have somebody will dominate, like Serena Seaforth. I know Seaforth would take the center stage, like what he did this after the Supreme Court decision. And I've said it here. Mind you, let me send this caveat. It is possible the Seaforth will say something contrary from what he just said. And what he said to the media is not binding. It's out of court statements. So when he goes to court,
I thought you were responding to my question. Is something else?
Yeah, I'm wrapping up. I mean, I'm just closing up all this stuff. Let me tell you something when it comes to public speaking. When you ask a question and there's an issue that you need to address them and leave an imprint in the minds of the listeners, you address that.
Sure, go ahead.
All right. So in my opinion, the Supreme Court decision has prejudiced the trial at the magisterial court. That's a key point that I want to say here. The second thing is the National Election Commission, whether they're going to, for that framework document is an issue. Jayweh will say, no, only that 8.5. But I will start there, Jayweh, I say, no, it's not only that 8.5, it's the signatories, the people who sign. That what make the document legal, not the 8.5. So the Supreme Court can say, we scratch this one here. And some people agree to go, we agree. No, they are no longer part of it. So do we consider that as a document that you bound them? We say no. So if you do that too now, that same document, the issue in it is say somebody committed fraud. That case is in the court. So what do you expect magisterial court to say? Serena Seaforth say that case, the Supreme Court decision ends the case at the magisterial court. Jayweh agrees. So what do we all say? What do we say? We should make analysis of it and see where the country goes from there. And I think this is where I would say thank you guys for inviting us. And I was glad to be here. And everything we say here, lawyers should always, I follow the example of Justice Cllr. These are people who ask questions. They're telling civil society, the media, you need to survey and know what the justices are doing. Ask them questions. So that when they're making decisions, they make decisions in the interest of the country.
Thank you.
Thank you.
So that's the basis of Communist Talk Show. We want to say, hey, justices, we respect you. You are honorable men. But when you make a decision, there are lawyers who make analysis of the decision. And my decision is the Supreme Court ruling on this matter has prejudiced the case at the magisterial court. Just as Jayweh is thinking that Seaforth's statement was prejudicing the case at the magisterial court, one more you talk about the Supreme Court decision when the case is still at the magisterial court. What has happened? So that's my position.
Thank you.
There's no way they respect to the Honorable Supreme Court and the Chief Justice.
Now you're scared of contempt.
Look, my man, I wish I would have been in Liberia. I would be glad to go there and tell the justice.
Thank you. Councillor Jayweh, before you come in, I just want you to take a short 30 seconds to take a look at this.
Do you think the Supreme Court ruling today is an unaccordion of the case?
Grossly to a large extent. I said, when the court rule, whether directly or indirectly, has binding effect on all individual residents within the borders of the Republic. Thank you.
So Cummings' right have been restored now.
Automatically restored. But without prejudice.
That was
the SG has no match because the people who
and that's your closing, sir.
Yeah, and that's my closing. The lawyers who have been crying all along could not do what they're supposed to do to protect their client. So SG was doing what he could do. Again, let me close by saying the two cases are separate and distinct. At no time is the Supreme Court on any legal obligation to wait for an inferior court to make a decision before the Supreme Court can rule. That's not healthy for our society. And I will ask our people to read deep themselves, read on what the Supreme Court does and the authority of the Supreme Court. Thank you for inviting me.
Thank you. Mr. Sieh.
Dennis, I think we had a great discussion today. It was debatable, and that's how we intended it to be, so that people who believe that there are two sides to the whole issue can see the two sides. I hope we were able to do that. As a guy who is more about thinking about things politically, I think as you saw the celebration, I hope this will provide a level playing field for all the political candidates who have interest in this upcoming election. We have that opportunity to contest, because I want to be able to analyze. But I will say this to you: this decision by the Supreme Court, a political analysis is coming your way. Watch out for that on the Hour of Politics. It was good being here, Dennis. Thank you.
On that note, we end with our song that says, whether you believe that the Supreme Court decision prejudiced that in the lower court, or you believe the Solicitor General was the star in this case. In fact, he left Mr. Jensen and myself wearing red because of a red suit in court.
I know, right?
We are all like
before you close, Jayweh, happy to be with you, and I wish we talk more thereafter. My discussions, no way.
Attorney Jesse, Councilor Jayweh. I never want any attorney to call me Jayweh. I never want that.
Councilor Jayweh, I apologize, but I respect you as a senior lawyer, and if I say Jayweh, no harm to that. So Councilor Jayweh.
Thank you.
Okay. On that note, we end with our song that says, whatever political persuasion you may come from, we are all Liberians, and it is incumbent upon all of us to do whatever it takes to make our country the glorious land of liberty. Good night, and God bless you.
We are Liberians. Liberia is our home.